Good morning, I'm Dermot Graysbrook from Status Staffing, and this is
Michael Bagraim from Bagraim's Attorneys, and I want to comment on the new labour laws.
fantastic. Thanks for taking time to do that with us, Michael. Do you want to first just give us a bit of context around what happened with the new labour laws, how we got to where we are and what they are?
Sure. Over the last 3 years we've been debating the changes to the labour law. The evils that the labour legislation wanted to cure was the uncertainty that existed between the temporary employment services and the placement of employees, and whether the employees could look to the clients of the temporary employment services for some damages if in fact the temporary employment service disappeared. Obviously the trade unions had other ideas as well, in that they found it was a lot easier to organise at the client rather than the temporary employment service, specifically because the temporary employment service had employees at a whole lot of workplaces, and it became very difficult for unions to organise at the various workplaces. And unions being what they are, they wanted to try and regularize it and actually target one firm at a time, as opposed to a temporary employment service who had 10 people here, 1,000 people there, etc., etc. So those were the two evils that the law was looking at prior to the changes in the labour law. From the 1st of April this year, 2015, April Fool's Day, we saw the implementation of the new law, the amendments, the so-called amendments to the Labour Relations Act, coming into force. These amendments created a little bit of uncertainty in the marketplace, and obviously all of us were going out there to look at the law itself, to try and analyse it, and to try and see how it's going to affect the temporary employment service provider, obviously, and also the client. That uncertainty led to a lot of disquiet in the marketplace, and I think it led to some of the temporary employment services shrinking their own businesses, and the clients asking many questions. I personally, as a labour lawyer, spent months before the 1st of April going around on road shows to various of my clients to have a look at it and to see what could happen in the future. We then had the interesting ruling at the Commission for Conciliation, Mediation and Arbitration. We referred to it the CCMA. That CCMA ruling came out, and it was a very negative one. The ruling, lest them, I'm not sure what they were thinking when they came out with this ruling, they decided that in fact, because of the new law as from the 1st of April 2015, and after 3 months of employment, that employee who had been placed by the temporary employment service, they called it the labour broker, and they're synonymous, the two words, although labour broker in our circumstances in South Africa happens to be a swear word, so we call it the temporary employment service. They said that they weren't the employer. That's the CCMA said, that the temporary employment service was not the employer, and after 3 months the client became the employer, and that therefore if the employee had a problem he had to look to the client only. Now that created absolute havoc in the workplace. Many of the temporary employment services were in shock, and quite rightly so, because I think the judgment was wrong. I think it created more of a problem than the law did in the first place. And second of all, the unions weren't sure what to do themselves. They weren't sure where to turn and who to sue, because in fact, if it is deemed that the client is the employer only, and the client disappears, then you can't look to the temporary employment service, which creates a ridiculous set of circumstances. It's almost Alice in Wonderland. So we as labour lawyers were obviously starting to have a re-look at this, but of course, thankfully, the temporary employment service industry then took this matter on appeal to the Labour Court, well actually on review, and the Labour Court then had a careful look at this, and in having a careful look at this, decided that creates so much uncertainty, it creates so many problems, and it doesn't give the cure that the law was trying to implement in the first place. and it's turned it on its head. What's happened over here now is that the law is saying that the temporary employment service remains the employer for all intents and circumstances after the 3 months, and the temporary employment service has the responsibility of hiring, firing, paying, and in fact taking any action in terms of the Labour Relations Act. However, the one caveat is it does create an extra string to the bow of the employee. The employee can look to the clients if in fact the temporary employment service cannot somehow satisfy the ruling in terms of the Labour Relations Act or the Basic Conditions of Employment Act. So they're saying that the employee now has rights against the temporary employment service, who's the employer, and the client in terms of the new changes to the law. This makes a lot more sense. I don't think it's the end of the story. Don't hold your breath, because we are expecting appeals to that, and we're expecting challenges in the near future again. However, that brings some certainty to the market, and already we're finding in the marketplace the employers taking a deep breath and saying, well, at least we know where we're going as of now. I suspect in 2016 we're going to have more challenges, more fights. All this is good news for lawyers, not very good news for job creation.
Cool. Thank you for that summary, Michael. Just a couple of questions. What was the date that the CCMA ruling happened?
It was around about, I can't remember exactly, I think it was around about July this year that we had the CCMA ruling. They waited for the 3 months, the inflection of the 3 months' time, to show that 1st of April it becomes operative, then you wait the 3 months, and then you say, right, now we want to challenge it. So it was a carefully thought out application to the CCMA. I thought it was quite wise actually, and sneaky, because now what they're doing is they're going to a commissioner and saying the law deems that person, the employee, to be the employee of the client and not the temporary employment service. And I think they pulled the wool over the eyes of the commissioner in this particular case. The commissioner, of course, was looking at the law boldly and saying, well, in this particular case, the client is a much stronger institution than the temporary employment service, so that the client would be able to cure the problems of the employee quicker than the temporary employment service. The real problem we have is that some of the temporary employment services are fly-by-nights. And as you know, some of those people out there were called the Bucky Brigade. They used to take the money from the client, pay the employee less their commission, and then sometimes disappear. And so what the CCMA was doing is saying, let's be practical and expedient. What is better for the employee? I don't think they were correct, but in their wisdom in that particular case, they said it would be better to reside as an employee with the client. And so, to cut a whole long answer very short, the CCMA was looking for the expedient route as opposed to the legal route.
So, Michael, there's some, I suppose, articles have come out over the past few months about the Labour Court ruling on that CCMA case. What I'd like to do is just go through some elements of it and then ask you some questions. So, the decision by the Labour Court on the interpretation of the newly amended Labour Relations Act on September 2015, test case Assigned Services versus CCMA and others, has brought optimism for stability to temporary workers and temporary employment services industry who have witnessed job losses and business during this time of uncertainty. In the context of the job losses and the uncertainty in business, have you had any experience around this? Have you seen business impacted in this way, and how?
I certainly have. The business community is, and I think this is a notorious problem, is quite fickle. Many businesses, and especially smaller businesses, small and medium businesses, are fickle to the extent they're saying that if the law isn't certain, then we're not going to expand. We're not going to create employment. Many of my clients have been emailing, phoning and meeting with us and saying, well, you can't advise us which way to turn in these circumstances. And I kept saying to them, I don't believe the CCMA ruling is correct. And they're saying, well, let's hold on. And if necessary, let's shrink. And they've been doing that. And it's very unfortunate. We've just seen the quarterly figures come out for South Africa. I think it speaks for itself in that we've had a drop. We're probably one of the worst in the world in terms of unemployment. It's the last thing this country needs, to have uncertainty in our labour law. Yes, it's bad to have negative labour law, onerous conditions, and the circumstances around our labour law are not good. But on top of that, it creates a certain amount of uncertainty as well. So that fickle reaction from the business community has been translated into job losses. And we've seen some of the large labour brokers, some of the large temporary employment services, coming out with their latest figures. And we've all seen that in the business day and the business reports. And their latest figures have shown that their clients have put a hold on employment. And they've sent people back. They haven't created new permanent jobs, which is what COSATU, the trade union movement, was expecting. That didn't translate into permanent jobs. Everyone was saying before the changes to the law that if you can't place people temporarily, then obviously the business will have to create a permanent job. Well, that's not how the business people thought. They thought, if I can't have them temporarily because I don't know whether I'm going to get orders in the near future or whether I'm going to get customers in the near future, I'm then not going to create it as a permanent job. I'm not going to take the risk. I'm rather going to shrink my business. So I have noticed that. It's terrible to say it, and I've had my own clients coming back to me saying, forget it. That, of course, for me is it's a crying shame, because I don't have the work then. If they don't have employees, I don't get the work. That's what labour lawyers rely on jobs, because if there are jobs, then there are going to be problems. And if there are problems, then they call me in. And we've had a period now where we've actually undergone retrenchments. I don't think it would be unfair to say that my firm, Bagraim's Attorneys, as a small firm, has been doing more retrenchments in the last year now than we have in the last 4 years, which is horrific. So if you concertina the figures and you have a look at what we've done in the last 10 months, it's equivalent to what was done over 48 months in the past. And it's not that we have had good economic times in this country. So it's been a bad exercise, and it's backfired.
So the uncertainty it brings in the marketplace around TES and who the employee is deemed to be employed by, whether it's the TES agency or the client, the employer, I suppose the
client.
The client, yeah. There's talk about this now being settled. How properly settled is this, and is there any more uncertainty? And it's sort of how hard and fast is this interpretation of this aspect of the new amendments in place? And if so, can HR start developing IR policy and processes around this with the certainty that it's unlikely to change?
I think this judgment came as a breath of fresh air, and I'm hearing already from the clients that, thank God, the Labour Court has now finally ruled on this, and now we can start moving forward and planning our daily bread as opposed to worrying about whether we should employ people. I don't want to be a damp squib. I don't want to be a dampener on the whole exercise. I don't think it's certain yet. I actually have a strong belief that the trade unions are still going to sing. They say it ain't over until the fat lady sings. I think the fat lady's got to sing at some stage next year. Either they're going to appeal this particular case that's sitting at the Labour Court now, and I'm sure they're busy in their boardrooms right now as we speak, looking at it saying, are there gaps here? There was an interesting article brought out by Attorney Paul Benjamin last week saying that the judgment is wrong. Now, he is one of the advisors to COSATU. He wouldn't be writing that and saying that unless his clients had come forward and said, we're not happy. So I don't think COSATU is happy. I think some of the independent unions are happy. I've spoken to quite a lot of the independent unions, independent catering, hotel and allied workers union are very happy. They said, right, that's the ruling, that's what we accept, let's go forward and let's have some certainty. So the smaller unions who want to get on with their lives are happy. I don't think COSATU as an umbrella body is happy. So my short answer again to you is, no, this is not final. This is law in the making. We're living through history now in South Africa. Wrong time to be living through history. It's an old Chinese curse, may you live in interesting times. As a curse, I think it is a curse. I think that this is not a court of final countdown. It's still got to go to the Labour Appeal Court, and even from the Labour Appeal Court it could go to the Supreme Court of Appeal, it could even go to the Constitutional Court, because there is a constitutional issue here, because there's a right to employment in South Africa. So we've still got those tiers that we need to climb. I'm not sure if we will climb it. I don't know. My strong feeling as a lawyer is watch this space.
So, setting aside the previous ruling by the CCMA arbitrator, the client organisation is the sole employer of employees after 3 months. The Labour Court's judgment was that the deeming should be interpreted as augmentation rather than a substitution, and that the client organisation is a concurrent employer rather than the sole employer.
Yeah.
So, Michael, in this context, what does augmentation mean? And then we'll go on to ask what does a concurrent employer mean?
Concurrent.
And how does it translate into a real IR context?
Yeah. I think the judgment was good because they then left the door slightly ajar. What they were saying is the TES is the employer. Excuse me. Being the employer, they're saying then there is still some value in the triangular arrangement that exists in our law. And the value is that if the TES can't satisfy the necessities in terms of the labour legislation, the 11 pieces of labour legislation, let's say the TES hasn't deducted UIF, for instance. The court has now left it open and said that the employee of the TES can look to the clients to augment what the TES can't do, or hasn't done, or can't afford, or has disappeared, or whatever the case might be. And that's what's augmenting the rights of the employee, which is what the law is trying to do. The law is trying to protect the employee from the ogre of the business person. And so they use the word augmenting, the judge used the word augmenting, and the reality is that's what the law actually wanted to do. The law wanted to create more safety nets for the employee. And of course the temporary employment services, the good ones, the ones who have put into place all their services, they have backing, they have money, they have a relationship with their clients, those good temporary employment services are only too happy to say, yes, there must be augmented, there must be the safety nets. We want to protect our employees, and they haven't balked at that problem. So using the word augment is a good one, and in fact I think that truly describes what the legislature wanted to do. They wanted to augment the safety nets of that employee. Now, we then go on to say, and the judge said, that there is some sort of concurrent liability from both the temporary employment service on the one hand, who is the employer, and the client who receives the services of that employee of the employer. And they're saying that that concurrent liability means that the employee or the union can look to either one. And the lawyers use the phrase, the one paying, the other to be absolved. So that's what this is all about. There is a concurrent liability. And that concurrent liability, quite frankly, is a good one. So to answer your question, it just gives the employee rights from both.
So in terms of what that means, because I think this is where a lot of business is confused, is, well, if the CCMA or the employee can come after me, why do I use a TES? What's the point? What value does it offer? So does the employee or the union or whoever it is get to pick who they go after, or does it depend? So for example, if someone is a temporary employee with a TES agency and they're working at a big, say, corporate brand, because that's the client of the TES, and something goes wrong in terms of I don't know, like you mentioned, benefits aren't paid or pay isn't met or unfair dismissal happens, is the employer exposed as a first port of call? Is it a choice that, because in all likelihood, someone may want to go after what they see as the bigger name? Or is it only if the TES agency can't meet its obligation against the finding, and who decides that?
Yeah, I tell you what this court ruling is saying, and I think it's clear, and let's not get ourselves confused. The court ruling is saying that the TES, the Temporary Employment Service, the labour broker, is the employer. And they put a full stop next to that. They're also saying that if that TES can't meet the expectations of the law, then the client has to step in. Now, when you sue, or when you take someone to the CCMA, it would be wise of every employee in every trade union to cite the client alternatively. In other words, the first respondent will be my employer. The second respondent will be the client. Now, yes, that will put the fear of daylights into the client, because they're saying, well, we're going to the CCMA now anyway, because we're the second respondent. And it's wise to put them as the second respondent for a whole lot of reasons, but the one being is that if the TES doesn't satisfy whatever the ruling is, they become liable. So they'd like to be there and be informed of what's going on anyway. What the TESs are saying, the secure, solid TESs, the labour brokers that have responsibility, are saying, we will indemnify. We know that you're going to be the second respondent. And you and I have discussed this in the past, and we know that what's happening is the TES is saying to the client, here's an indemnity. We will stand in and satisfy every single ruling. Please give us that opportunity to satisfy it. We don't want to hide anything, so we'd like you to be fully aware, and we're happy that you get nominated as the second respondent, because we want you to be fully aware of what happens in our business. So if the employee is saying you didn't pay UIF, I think the client ought to know. And that's why I've always said, and I think both of us have said, that the client needs to have full insight into the books and the practices of the TES. Long gone are the days where you had that bucky brigade saying it's none of your business as to what I'm paying for my employee. That doesn't exist anymore. So the employee himself or herself will in fact nominate first the employer, first respondent is the TES, and will nominate the second respondent as being the people where I work. And that's what the law is now asking you to do.
So acting Judge Martin Brassey found the following, amongst others: the TES remains the employer of its employees beyond the 3 months. Is there any update on this? Anything employer should
No. Let me first tell you that Judge Brassey, acting Judge Brassey, is probably one of the country's foremost labour lawyers. He's been practicing labour law for many, many years, I think for 35 years. Judge Brassey, acting Judge Brassey, was one of the authors of the current Labour Relations Act. And Judge Brassey has very carefully had a look at the wording of the current amendment, and hence his judgment. I think the judgment is correct. I think we're going to see some amendments to that judgment, maybe on appeal or on review. We're going to see some commentary on it. And I think Judge Brassey has left it slightly open for further interpretation. But as the law currently stands, and I think for at least the next 12 months, Judge Brassey's judgment is the law.
And if it was changed after 12 months, any case decided within that period can't be retroactively applied?
No. No. So this is the law. And Judge Brassey, and in fact, in 2 weekends' time, I'm going to be spending the weekend discussing labour law with him. We're getting a group of people together to discuss the labour law. Obviously, foremost on my mind is this judgment. He's worrying about another judgment, and that's why he's getting some labour lawyers together to look into another issue, which we'll have a debate on some other time. But foremost on my mind at the moment, because my clients are all clamouring to find out, is this the law? It is the law. There's no update on it, that's the law, and we can be rest assured that that's going to be the law for the next 12 months, and we can also be rest assured that if any changes to the law happen, it's not going to be retrospective.
Okay. The extension of the deemed provision is sufficient only as far as extra protection to TES employees in terms of the Labour Relations Act. What does this mean in practice?
What it means in practice is that the TES stands in as the employer, that it's business as usual, that we can go back to where we were before this CCMA ruling. We can have a look at it on the basis of the TES is the employer, the TES will place that employee with the client, and the TES has to hire, fire, discipline, etc.
Okay. Nothing in the law states that TES is to be substituted by the client after the 3-month period. From what you've seen, have employers been behaving like it did?
Yes, there was, obviously after that CCMA ruling, there was that uncertainty, and the clients panicked. The clients said, well, if we're the employer now, what are you doing there, and why are we paying you, and what's the issue? And there was that running, the scurrying around. It was a situation of almost chaos.
And before the CCMA judgment, but after the law came in, we were seeing similar things where everyone was being made permanent or...
Correct. But, before that judgment from the CCMA, the clients weren't sure, because some experts were saying A, some were saying B, clients weren't sure. I think this ruling now from the Labour Court gives a good lid to this problem, and it's not bubbling over at the moment. Yes, there is some pressure building, but it's not bubbling over, and we can be rest assured that the law is certain now. For a time being, but it's certain. It's certain that the TES, the Temporary Employment Service, is the employer. After the 3 months, still remains the employer.
Okay. The principle of triangular employment relationship, as per the original section 198. What does a triangular employment relationship mean here, and what difference does this make in practice, if any?
Yes, the triangular, and I think most of the TESs who were responsible looked at it as a triangle. They're saying, we as the TES at the pinnacle of the triangle, we then employ an employee. We then place that employee with a client, and the client looks to us to hire, fire, and to take the action, the disciplinary action. So it creates that triangular relationship. What Judge Brassey is saying in the Labour Court, he's saying that triangular relationship is only necessary in our law when the TES doesn't satisfy the law. If something goes wrong and the TES hasn't satisfied the law, then we can all look to the client and say, this TES, he's gone off to Honolulu, he's disappeared with the salary, he hasn't paid the employee, now let's look to the client. And that's what he's saying. And he's saying, yes, the triangular relationship is intact, but it is the lines between the employment are very strong between the TES and the employee, not the other way around.
TES place employees have an election only when there's a dispute relating to rights under the Labour Relations Act to prosecute such against either the TES or the client. What does this mean, and is it something employers should be aware of?
Yes, the employer should be, the employer is the TES, and the employer should be aware that if he doesn't pay over workman's compensation and the employee gets injured, the employee is going to say, no, I haven't got anyone to pay for my injuries. What the employee will do is he will look to both the TES, his employer, and to the clients. And again, in circumstances such as that, one paying the other to be absolved, as soon as the TES doesn't pay, or can't pay, or is bankrupt, or has disappeared, the client becomes wholly responsible at that point. And that's really what it's all about. What Brassey's doing is, I think, correct in our law. He's saying, come hell or high water, that judgment must be satisfied. I've broken my legs, I've fallen down the ladder, I worked for a plumbing company, I was placed there by a temporary employment service. I don't care who pays, the colour of money is the same. I want someone to pay for my broken leg. And that's what he's saying.
The CCMA Commission made material errors of law requiring the Labour Amendment review. So basically, did the CCMA interpret the new TES and Atypical employment amendments incorrectly?
I believe they did. The judge said they did. The Labour Court stepped in and said, you can't create a fiction that although you were employed by the TES and although you were placed there and you're still getting your salary from the TES, they suddenly created a new fiction and saying the TES doesn't exist. Let's forget about them. Let's purely see the client as the employer. And that's a fiction. And it doesn't matter how much we try and create that fiction and conjure it up, they made a mistake.
Have you seen much change in IR practice in organisations since the introduction of the TES Labour amendments?
Yes, I did. The true change came in when panic was sown into the minds of the clients after reading the CCMA ruling. And that panic was that all of a sudden they better look at the hiring practices of the TES, they better look at the firing practices, they better have a look at what the deductions are. And they're saying, if we've got to now control all of that, why do we need the TES? Because what's happened is the CCMA has made us wholly responsible and them not responsible at all. And so, yes, it's sort of changing their dynamic. And of course, what happened was many of the clients said, well, why do we need them? If we have to do everything anyway, why do we need them? And what's happened subsequent to the Labour Court ruling, that ruling has at least put some certainty back, saying the reason why we go to the TES is because they're experts in employment. They're experts in the Labour Relations Act. They're experts in firing. They're experts in discipline. And they can control it. We as the client, we're expert in widget making. We don't want to have that responsibility of that employee. And so again, the law has shifted the balance back to normality and saying, yes, they are the employer, they are the experts, that's why they're in the market. The only reason why a temporary employment service is in the market is because they're experts at handling the admin, handling the controls, etc., etc., and it frees up the business to carry on with what they normally know how to do. And if we are manufacturing motor vehicles, we're not experts in providing our employees with food. So we're not experts at food production. So we go to a TES and say, well, you then appoint people to run a canteen. We don't know how to run canteens. We manufacture motor vehicles. And so that's then shifted the balance back to normality once again.
Yeah. APSO found that APSO is a founding member of the Confederation of Associations in the Private Employment Sector, and when it did a survey of its members, it found that only a small number of employees were permanently employed by clients' organisations, 20% in the 12 months following the amendment. Is that your experience, and have you seen many companies impacted by this, including in the recruitment sector?
Yes, and APSO's survey, I think, reflects the truth of what actually I've been seeing. Obviously, my experience is anecdotal, but I have been seeing that very few of those that were placed as temporary employees then became permanent. Some, they said, if you got 50 there, they said, actually, this one man, we want him as permanent because we can see that the future. But the other 49, they said, well, let's rather retrench them or send them back to the temporary employment service. We can't take this risk. And so it's been a very negative downtrend that we have seen. And APSO's survey, I think, speaks reams as to what actually is happening in the workplace.
Okay. Knock-on effect, this resulted in the following with a number of small to medium-sized recruitment companies, many of which were black-owned. Have you seen that too?
I have. One or two of my clients obviously have decided to close up shop, saying, well, if they can't place people, because the clients are saying, well, you can place people on a permanent basis. That goes back to the old employment agencies, when some of the small businesses in the TES sector relied on placement of temporary employees as opposed to permanent employees. And of course, many people are saying, I don't want to permanent employees because I'm not sure what my future is as a client. They're saying, well, we've got no business now, so it's closing it down. I've seen anecdotally a few of those businesses close. I think they may be a bit too hasty in closing down because there's now some normalcy back in the market.
The industry certainly believes so in terms of this matter being closed, but we recognise the right for the Union of Metal Workers, NUMSA, to appeal the ruling should they do so, and we believe, this is the Chairman of Capes, that the prospect for success is poor. Do you think that NUMSA will, or any other union will, appeal, and do you think that business should be worried about what the result might be?
I don't think they should be worried because the wheels of justice turn slowly. So even if they do appeal, this could take anything up to 2 years, and 2 years in any life of a business is a long time, and we have to get on with running our businesses. So I don't think there's worry out there. Yes, as I've said earlier, I do believe that either NUMSA or one of the COSATU unions will step forward and appeal that or challenge it again. We're going to have many cases going to the CCMA, and the arguments will then arise again at the CCMA, and then there'll be reviews coming through. I don't think Brassey's judgment at the Labour Court is the final word. The fat lady has not sung. The fat lady is in fact the Constitutional Court. We're only at the first level of the Labour Court. But like I said, I don't believe we're going to see any changes in 2016. People are going to be running their businesses in terms of the Brassey judgment. NUMSA hasn't even at this point put in papers to consider appealing his judgment. They still have time, but they haven't even considered it yet. Obviously they've been to attorneys, because we saw the Benjamin ruling, the Benjamin opinion on Brassey being wrong. I think Brassey's the correct lawyer in these circumstances, and I think business now can be rest assured that 2016 is business as usual.
Okay. And is there anything that we haven't mentioned about the new Labour amendments or the Labour Court ruling that we should have mentioned?
Well, yes. I think what becomes very important is a political statement, because what we are seeing, and this has become well known, is that union membership is dropping. And the unions were behind, the force behind these amendments in the first place. And I think the employees themselves, the members of the trade union, are saying they also want certainty. Not just the TES and the clients, but the actual employees saying, I want certainty. I can't bear, who do I fire, who's going to fire me, who's in control of me. I can't bear that anymore. And in fact, in their droves, they're leaving the trade unions and they're saying, we have to rely on our employer. We want to negotiate directly with our employer, we want to speak to them. And in fact, the clients, the people who receive these employees, are also finding that many of those employees are saying, we don't actually want to be a member of any trade union, because When we negotiate, we're going to go and negotiate with our employer, and when we offer our services, we want to talk to a TES that is a solid one, someone that we can trust as well. So that triangular relationship is becoming more important also to the employee, because that employee is saying, I don't want an outsider such as a trade union who takes my money every week but not giving me the
I
service.
don't know.